All right. Morning, everyone. We're on the record on State versus Loyd. Mr. Loyd's present with his attorneys. State Attorney's Office is present. Mr. Loyd remains in custody. He's dressed in a black long-sleeve shirt, pink tie, civilian pants. He is wearing jail shoes and shackles. His feet are under the desk and can't be seen by the jury from any angle in the courtroom. All right. Penalty phase. State, you ready to go?
When I take 15 minutes to my first witness here.
I can't hear you.
I'm sorry, I'm informed the first witness is here, so we're ready to go.
Okay. I do have two things to address from the defense. I have a motion in limine to prohibit mention of prior juvenile commitments and charges. State, are you intending on trying to admit those?
No, we don't intend to introduce any evidence of that on direct. However, some of the defense experts did testify about his juvenile history. It becomes appropriate to cross-examine them. I was supposed to do so, but if I am going to, I'll advise the board and approach sidebar before I go there.
I mean, if the defense experts testify to it and the defense opens the door, that's a different matter. Just let me know in case there's additional objections that need to be put on the record. And then I have a motion to introduce evidence of bias and impeachment of Dr. Pritchard. Mr. Lenneman, if I can follow your motion, what you're asking me to allow you to do is to let the defendant's sister testify to a conversation that the prosecutors were having with the victim's family about trial strategy that Dr. Pritchard was not a party to. Is that correct? Okay, motion denied. Anything else before we bring in the jury?
I just wanted to make sure.
What?
Did you send the final jury instructions to us? Because I know that you...
I did. I
Okay.
asked if anybody had any objections
Okay, I just
to the
wanted to make
preliminary ones. All I changed was the, added the second count he was convicted of the killing of an unborn child.
Sure. Okay, thank you.
Sure. Anything else? All right, jury's ready. Let's bring the jury in. State recognized presence of the jury. Defense.
Yes.
All right, welcome back, folks. Good morning. I hope you all had a good weekend. This is the penalty phase of the proceedings. I have some instructions for you, and then we'll work our way into the remainder of the penalty phase. Members of the jury, the defendant has been found guilty of one count of murder in the first degree and one count of killing an unborn child by injury to the mother. The only issue before you is to determine the appropriate sentence. The punishment for these crimes is either life imprisonment without the possibility of parole or death. The attorneys will now have the opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, 1, whether the aggravating factor is proven beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, 3, whether mitigating circumstances are proven by the greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide you in your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of imprisonment without possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. Before moving on to the mitigating circumstances, you must first determine that the aggravating factor or factors is or are sufficient to consider imposing a sentence of death. If you do not unanimously agree that the aggravating factor or factors is or are sufficient to consider imposing death, do not move to consider the mitigating circumstances. Your verdict is life without the possibility of parole. Should you find one or more sufficient aggravating factors exist to justify recommending the imposition of the death penalty, it will then be your duty to determine whether the aggravating factor or factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Any further instructions requested by state?
No, ma'am.
Defense?
No.
All right.